Everybody, Daniel Sherman here. It's Sunday morning. I'm here at the office. I've got some work I have to attend to. So I wanted to continue with the second part to my Kentucky Rules of Evidence explanation. So the first one we did was regarding questioning, leading questions, direct examination, cross-examination. And those are not like hard, fast in the rules of evidence. I mean, they are, but it's not, it's kind of cumulative. It's not like a hearsay rule or best evidence rule where you specifically says, rule 801 says this, rule 901 says this on authentication, 1001 says this on best evidence. So these are, that one is kind of more just kind of found throughout the rules. And more kind of developed through common law. And if you don't know, common law is, judge-made law, basically. It's not necessarily written. So what I want to talk to you about today in our second series is foundation, laying a foundation. This rule is very near and dear to my heart because the first time I was ever had an evidentiary hearing, there was an objection made to, foundation. And I'm going to be honest with you, I was licensed for less than a month, and I had no idea what a foundation was. But I quickly learned. So I guess that's the good thing. And, it was one where I think the judge was it was not in our county. It was in Warren County. The judge was very good with me and, tried to kind of help me as much as I could as far as, now, Mr. Sherman, make sure you lay a foundation for it. So I kind of had to, figure it out on the fly. But, what a foundation is before you introduce evidence and really even ask questions, which is, still introducing evidence, you have to let the finder of fact, that's going to be either the judge or the jury, know the circumstances surrounding the evidence. So that's going to be the date, the time, the place, the circumstances. That gives a foundation for what you're asking. So, for instance, in a lot of divorce cases, we'll introduce text messages, and there's different things for authentication. We'll get into that later, but you have to lay a foundation. So, foundation for a text message would be like, "Hey, have you and your husband? Do you all send text messages? Okay. I want to talk to you about a certain text message. Can you describe to the court when this text message was sent?" I'll describe, hey, it was sent on September 5th. The approximate time it was sent. It was sent at 5 p.m. And who was involved in this conversation? Well, me and my husband. And then after you introduce the text message, you can just say, can you just describe the conversation for the court? And then you introduce the text message. So the foundation is, who was this message in between? When was it done? What time was it done? And what are the circumstances? So that's laying a foundation. In a criminal case where you're laying a foundation, and it's typically set forth in an indictment or a criminal complaint, it kind of gives you the foundation. But let's just say somebody broke into your house and you were present and you're testifying. The prosecutor is going to ask you, okay, where were you on the night of November the 5th, 2025? I was at my house. Okay, were you awoken at some point in time in the early morning hours of November the 5th, 2025? Yes. Okay. Do you remember what time you awoke? 1 a.m. Okay. Can you describe the facts and circumstances that led you to waking up? They'll say, well, I heard a noise. And what did you do to investigate that noise? I went downstairs. And what did you see? Okay. I saw the defendant. Okay. And so you go from there saying, this is what happened. Can you tell me when it happened, what day it happened, what time it happened, and the circumstances surrounding that? So in any question, really, there has to be some kind of foundation. Now, a lot of times you lay the initial foundation and then you ask 30 questions based on that foundation, which is fine. So you don't have to necessarily lay a foundation for every question, but for any group of questions, you have to lay that foundation. Because if you were just to come up and say, hey, Can you describe me that text message? You're going to hear from me, Judge, objection, no foundation. And so it is something that has to be done, and it kind of narrows it down, because if you're talking about, say, a text message, it could be, from 10 years ago. We don't know. That's why we need the foundation. Or especially in criminal cases, when you're, narrowed down to, specifically this date, this event occurred, you have to get into that date, because, we're not trying somebody for something they did 5 years ago. We're trying for something they're presently charged for. So that is what a foundation is, and it has to be laid in every series of questions. And, as attorneys, we kind of do it naturally. But I will say, if you're not an attorney and you're not used to doing it, it can be kind of daunting, because you just want to say, well, tell me about this text message, or didn't you tell me this? And it's like, no, okay, on this date, this time, where were we at? So that's the foundation. So hope this has been helpful for maybe some of you pro se litigants, or just, if you're sitting next to your attorney and you hear that and they don't say objection, foundation, then you may need to get a new one. So y'all have a good one. Take care. You know how to get a hold of me. Got my phone number, contact down below. Take care.